That lady now, it's the Zoom lady. She wasn't there in the past. Well, but let's just start it again and then make sure that I have it correctly. I mean, I know you got this mediation with the Attorney General, with the Education Department, but now you need the legislature. And how is that going, and where is it stalling?
Well, we have a bill now. It is in both the Minnesota House, which is controlled by Democrats, and in the Senate, which is controlled by Republicans. We've had an informational hearing in front of the Education Finance Committee in the House, which I think went quite well. We have had no proceedings yet in the Senate. The legislative session ended on Monday. Monday was the 17th. There will be a special session at some point during the summer, but I am not sure, and I have my doubts that the special session will take up our bill. What this means is that we will be going back to court. My decision is that I will go to court and I will ask for a summary judgment that the state of Minnesota has violated the education clause of the Minnesota Constitution, specifically the legislature, which has a duty to provide a general, uniform, thorough, and efficient system of public schools. The Minnesota Supreme Court has said that it is self-evident that a segregated system of public schools is not general, uniform, thorough, and efficient. They said that in our case. Mm-hmm. Now, there is no dispute that the schools in Minneapolis and St. Paul, and in fact elsewhere throughout the state, are segregated based on race or socioeconomic status. We've just completed a 2-year mediation, which has produced the agreement and this bill that is in the Minnesota legislature. We made the agreement negotiating primarily with the Attorney General's office and the State Department of Education. So they now know what both sides have agreed on should be an adequate remedy to redress the problems of the problem of segregation and the problem of the achievement gap, which has persisted for decades here. So I'm going to go into court. I'm going to ask the judge to enter that judgment that the segregated schools violate the education clause and enter an order that the legislature has to fix that. Because of our 2-year mediation and the bill, they now know exactly what they need to do in order to fix this problem. But I think they need a court order to do what's right. So that's my intention, and I plan to, I hope, have an order by the end of the year or before the end of the year.
Would that then require that the Senate come on board essentially verbatim for what the Assembly has been and what you've agreed on in mediation, or is there still room for further negotiation? Does that create the opportunity to backslide on some of this?
If there are things that would improve what we've agreed to, of course we'll listen, and of course we're willing to talk about that, because I would hope, I know that the Attorney General's office and the Department of Education have the same interests that we do. And if legislators have ideas to cure this problem and improve education for Minnesota children, of course we'll listen. And if that results in changes, if they're beneficial, that's great.
Your solution, as mediated and is now before the Assembly side, is sophisticated. Yeah. This is not old school desegregation, closing down dual systems. We're all set. And there's a lot of layers to it. I've noticed by a sense of mandating that certain schools certain school districts that have advantages that are adjacent to those who have less advantage must participate in this. And is that a fair read of what you're trying to do?
That's fair. Let me say 5 things about the bill, that is the solution. Number one is the idea. Number one is that the entire state of Minnesota is going to be sorted by census tract based on socioeconomic factors. And the big four factors are, for each census tract: median income, average educational attainment, number of single-family households, and let's see, income, single-family households, educational attainment, and of course I can't remember the fourth
No,
one.
I've seen it written down somewhere.
Yeah, it's in the bill. It's in section 2 of the bill. Home ownership, that's the fourth one.
Right.
Percentage of home ownership. That will give 5 tiers. Tiers 1 and 2 will be the most economically advantaged. Tiers 4 and 5 will be the most disadvantaged. Now, the 2 main drivers of integration and educational improvement in the bill are, first of all, an interdistrict desegregation integration program, which will, as you mentioned, will be compulsory for any district that is racially or socioeconomically identifiable, meaning that there is an undue proportion of underserved students, traditionally underserved students, and students basically on free or reduced lunch. And any district that is contiguous to an identifiable district, and they can be identifiable if they are, for example, segregated white or segregated affluent. They will have to participate. Now, there are 2 other features of the bill, which is, one, schools that are participating, that are required to participate, must come up with a 3-year plan, after which they will not be identifiable. However, the plan, no student, and that plan will obviously involve preferences for enrollment, but for tiers 4 and 5 students. However, the plan will not be compulsory for parents. Nothing about this is compulsory for parents. School choice is preserved. That is a third feature of this. And second, there will be no preference given to any child for enrollment based on that child's race. There are no preferences based on race. All preferences are based on socioeconomic status. In other words, closing the wealth gap in this country. And there is nothing, so far the Supreme Court has not said that billionaires are a protected class. So it is not, they're not going to be preferences based on race. All preferences will be based on socioeconomic disadvantage. No parent choice will remain subject to capacity constraints, which is exactly what it is today. And the final feature of this will be a program of basically a state-run program, system of magnet schools, which will be set up throughout the metropolitan area, initially with 4. The idea being each school will have a theme. It will be top quality education, and it will attract students from throughout the metro area with at least 40% tiers 4 and 5 students. And now the so-called 3-year plan that each participating school or district has to prepare is not just about integration. It's about all kinds of educational improvements, including implicit bias training, recruiting teachers of color, adopting best practices in terms of pedagogy, relevant, making curricula relevant, equitable discipline, and use of restorative practices to keep kids in school instead of suspensions and expulsions. And the list goes on. I mean, the bill lists about 15 things that will improve education that are going to be in that plan. Now, one thing that's not in the plan, but I hope our federal government is providing, because I know President Biden wants it, is universal pre-K.
Hmm.
Well, if it's not universal, it's got to be for tiers 4 and 5 kids.
Mm-hmm.
And one of our experts in this case who took part in the mediation is a professor named Rucker Johnson from Berkeley. He is one of the leading scholars of integration and desegregation. He's written a book called Children of the Dream, Why Integration Works. And he said that 3 things together have a synergistic effect. Integration, investment, and pre-K. And when those things coincide, you see incredible improvement for underserved children. And his research covered African Americans beginning in 1945 through graduate, basically almost up to the present. So he covered generations, and he found that African Americans that left segregated schools and went to integrated schools did better in school, went farther in school, made more money in their careers, stayed out of the criminal justice system more, and then had better health outcomes, which to me is a clincher of why integration works. So that, I mean, our bill covers the waterfront, but leaves it to the federal government and President Biden to get us universal pre-K.
Well, you got to give him something, to kind of pick up. You can't take care of all the problems in one fell swoop. But let me go back to an issue that obviously is a sensitive element. The system says that race is not part of this, but in 2 ways it is. The simple, explicit way is that you have your definitions of historically underserved students, which then gets into a few lines, including students of color and indigenous people. So in a sense, it's woven into the fabric, but probably even a bigger sense, so many, if not most of the children and families that are in those tiers that are living in poverty are also children of color. And so in essence, there's going to be a racial change in Minneapolis, St. Paul, isn't there? Or in the greater area, should this go through?
Yes, there should be. I mean, that's what integration's about.
Yeah.
And
why is it not explicitly stated? Is that an important thing politically?
Because we know if it's explicitly stated, first of all, because we are confident that preferences based on poverty cannot be attacked as reverse discrimination under current law. I mean, that's the big reason.
Yeah.
Do we have a Supreme Court today that would say that separate can be equal? I mean, a U.S. Supreme Court, who wants to take that chance?
Right.
But if the preferences are based on socioeconomic status, we think that would be immune from challenge under the U.S. Constitution.
And it also strikes me, and which I referred to in the sense that if you're trying to get the Republicans, or if the Republicans end up being told by the court they need to approve this, that there's some side of our country, which we've seen even in just this last election, that might see this economic argument as one that they would accept more than just doing it purely on base. Is that, as part of your calculation?
Absolutely. I mean, parent choice is preserved. Parents don't have to send their children to schools they don't want to send them to, and nobody gets a preference based on race. Those are things that I think will appeal to Republicans.
And I still see the word or the phrase or the operation of busing. Does that still have some kind of critical phrase that you also would like that not to enter the conversation, that
Well, of
just
course,
going
I
back to
mean,
busing?
people use that. I mean, busing is a dog whistle to conservatives, but one of the things that we do require under the bill is that the state cover transportation for kids for families that are taking advantage of the opportunities they have to go to what they consider to be better schools. And there's nothing wrong. There's nothing wrong with that. I mean, it's not, but it's, as I say, it's not mandatory. This is not mandatory busing, but it is mandatory that the state cover that transportation so that families that don't have the resources to pay for it themselves can do so. In the Twin Cities, we have some very excellent private schools, Blake, Breck, St. Paul Academy, Minneapolis Academy, and they draw students from all over the metro area. And parents don't complain about their kids having to travel an hour or more to get to those schools because they know they're going to get an adequate education. They're going to get an excellent education. And that's what every parent wants. And that's what we want to provide as well.
I have here, if I can just indulge for a second. We talked last time a little bit about, this concept of the state is the way to go, that the federal system, in the federal court system, the Supreme Court's made it clear that they're not open to further action on issues of segregation. But you said, every state that has a good education clause can make this similar claim. This happens to be New York State's education clause. And it doesn't sound as sophisticated or as lengthy as the one that you have in Minnesota. It says the legislature shall provide for the maintenance and support of a system of free common schools wherein all the children of the state may be educated. Do you find that, in your opinion, to be strong enough to take a similar action in New York State?
I think it is for a number of reasons. First of all, there's a mandate on the legislature. The language is it's compulsory. They must do that. Shall provide for them. All right. Second, you don't. I think that implicit in that is the idea that this has got to be a system of adequate schools.
Mm-hmm. Mm-hmm.
Third, implicit in all of this is that a segregated system of public schools is not adequate. It's not general, uniform, thorough, or efficient in Minnesota, and I doubt that it would be deemed adequate in New York. And I know New York City in particular has this struggle, but
yeah. And then there's also, this is the state equal protection clause too under the Bill of Rights, and again, this is similar to the federal, I suppose, but it does say explicitly, no person shall be denied equal protection on the basis of race, color, creed, religion, or any discrimination of her civil rights, which is pretty powerful for what looks like it was adopted in 1938.
Yeah, here's why the education clause is a stronger vehicle, because the general interpretation of the equal protection clauses that you see, yours says no person shall be denied.
Mm-hmm.
That means that there has to be action taken to deny. Somebody has to act to deny. They have to do something that denies that right. So that usually has been interpreted, that language, it's certainly the federal interpretation of the equal protection clause. There must be an intent to deny, unless it's a fundamental right. That's different. But under the education clause, it's not, they violate that by not doing something.
Right.
Not by doing something. They violate it by failing to do what they're supposed to do. So it doesn't matter, intent shouldn't matter, because it doesn't say you can provide, you have to provide this unless you fail to provide it for some decent reason. It says you shall provide it.
Right. And then either you're providing it or you're not.
Right.
And if you're not, then you must.
right.
right? And,
So
and
that takes intent out of the equation,
that
in
sounds
my view.
that sounds like a similar argument that you were making, where you won that, in 2018. Is that similar to?
Yeah, the Supreme Court didn't reach that point it didn't reach the issue in its opinion, but I did argue that.
Yeah.
And I still think I'm right. And back in the trial court where we are, we have 3 charter schools that intervened in the case to try to stop what we were doing.
Mm-hmm.
And they, in Minnesota, where charter schools began, not many people know that.
Yeah, I didn't realize that till you told me a few months ago. Yeah.
Right. Well, they have an exemption, charter schools, from any desegregation rule or regulation. They filed a motion that to have that exemption declared constitutional. I opposed it, and I said that exemption was part and parcel of an intentional action by the state to resegregate schools and resegregate Minnesota schools. The court denied their motion, said there was enough evidence for the court to find that I was right, although it didn't make that finding then, because it was simply whether they had presented enough evidence to prove that I was wrong. But the court said no and denied the motion. So if I have to prove intent, the court has said there's enough there to do it.
Yeah, but it's better to not have to.
That's right, and I shouldn't have to.
Yeah. Do you feel like you're one of the first to make the arguments along the lines that you have in a state case across the country? Are there others? Did you copy anybody else's work and borrow it and transfer it, or did you just a little bit of both, maybe?
Yeah, well, I did when I started. This is the second one of these cases I've done. The first one was in 1995, and there I modeled what I was doing on a case in Connecticut, Sheff versus State of Connecticut, SHEFF. Now, and Sheff did have a claim about segregation, but it was based on a clause in the Connecticut Constitution against racial discrimination.
Mm-hmm.
So I am my case is the first one ever to make the argument that an education clause itself prohibits, that a violation of the education clause alone that segregation in itself constitutes a violation of the education clause.
Right.
And so we're the first to not just to do that, but to win on it.
Yeah. And maybe it won't be the last.
I hope not. I know they're following this case all over the country, the lawyers that do this work.
Yeah. And I mentioned to you that I'm not aware, and I've talked to some of the the more localized academic guys that follow these issues, and they're not aware of a New York State case simmering on this basis. Although New York State had a lawsuit going back almost 15 years ago, which was solely based on the amount of money going to school districts.
Right, funding case.
Yeah, a funding case, and it's still barely being paid out. In fact, I think the governor's current budget now, they're finally saying, well, we're trying to make good on that. Billions and billions of dollars over 15 years, which now end up being not very much impact. And the story that I just aired 2 weeks ago is about a school in Syracuse, Dr. King School, which was one of 3, in essence, unitary, in essence, segregated schools back in the 60s. It was the other 2 closed. This one stayed open. And of course, it's had a few better periods than others as they tried to integrate in the 70s and into the 80s. But for the last 15 years, it's been a failing school by everybody's definition. And in the numbers that are most current, which are about 2 years old, in the 3rd and 4th grade on the testing, I believe it's in the range of 112 Black students, 10 Hispanic, 5 mixed race, 1 white, and a 3% proficiency on passing the English language exam. 3%. The state average is 52%.
So,
Everybody's not proficient, but at least half the state is, and it's 3%. Yet nobody's discussing it. I don't understand. And it just gets back to exactly what you're working on, this interdistrict concept.
yeah,
Onondaga County surrounding Syracuse could fix this problem fairly simply. It's not that big an area even,
yeah,
and you mentioned New York City. That's a really tough nut.
yeah.
But we're not New
New
York City.
Jersey has got a case now based on racial segregation.
Yeah,
And
yeah.
so,
Yeah, I've seen some reporting on that and looked a little bit at the case, and that seems to be kind of tucked away in negotiation now too.
yeah, it's a little bit bogged down, I think.
Yeah, it's been a little while. So just to wrap it up, you hope to get to court maybe in the fall then? Is that how it would work?
Well, we'll be back in court, I think, much faster than that. What I want to do is get a conference with the judge, I think, quite soon, set up a schedule for me to make my motion, and I hope get a ruling on it by this fall.
Yeah, that'll be a big step. Is the governor with you on it?
It's hard to say. The attorney
Doesn't he have, maybe he
general,
doesn't have to be at this point. I don't know. I guess if it's a
right,
law,
and
he has to be,
he's got plenty on his plate, with COVID and the budget.
no doubt.
But I think he's done an excellent job. Although I'm also now an attorney with the ACLU here, and one of the things I've been fighting with the state about is the way they treat protect prisoners from COVID.
Hmm. They're not protecting them, or not fairly.
Not the way they should be.
Yeah, captive. No